hearing comments with a request by lawyers for Mr. Mahama that some 12 questions should be answered by the Electoral Commission chairperson. The court, however, listened to legal arguments and came to the conclusion that it was not relevant. But first, we can take a listen to some of the arguments that were made in support of the request for those questions to be answered and the arguments against.
I refer to the broad scope of discovery because all those orders, further and better particulars, interrogatories, and so on, they are all intended to narrow down the issues for the trial and to make clear what really is in contention between the parties. That is what I wanted to emphasize. So what we have sought in these interrogatories, in our respectful submission, will achieve the objective of narrowing down the issues before this court.
Being sought are in the petitioner's own petition, the answer filed by the first respondent and also the answer filed by the second respondent. Questions being asked of us that where did the regional coalition center pop up from is all in the law. That is why we are saying that everything is in the law before this court. Now, my lords, we would also realize that the questions posed seek to introduce through the back door new facts which are not anywhere in the petition before this court.
A proposed interrogatory which does not relate to a matter mentioned in paragraph A of sub-rule 1 shall be disallowed, notwithstanding that it might be admissible in cross-examination. So it's a well-established rule of the common law that a matter that may be refused in interrogatories may be allowed during cross-examination. So our position is that all the issues that they are raising here, and if you look at the pleadings, are not in contention. They have been sufficiently answered. There may have been admissions which put them out of contention. And the petitioner may have his occasion during cross-examination to throw some of these questions at the EC.
Subsequent statutory amendments pointed out after 2013 have provided us with new procedural regime and strict timelines. We are strictly bound to comply with CR90 and therefore we will not apply Order 22 of CR 47 of 2004 in these circumstances. We accordingly refuse to grant the application and same is accordingly dismissed.
The court dismissed the application and lawyers for Mr. Mahama's team and the president's team have been reacting to the decision.
Indeed, just to let you know that we were ready and prepared with our issues because the last time the court directed that there was going to be a pre-trial. Every lawyer knows that when the case is adjourned for pre-trial or case management, you have to prepare your issues. And if you bring an application to court, you either know that the application will be granted or dismissed. So there is no need to wait for that to happen. Much more so when you filed your application just about 2:40 p.m. yesterday. What did you expect? So yes, the application has been dismissed. Whatever they do afterwards is their own business.
Is your contention that
the real case in court has not started?
Is your contention that they are delaying the process? We heard your colleague make that point that he wanted to be dealt with.
Well, what else could be further from the truth?
You didn't need to even, I think that Ms. Jikata eloquently dealt with the issue of relevance, by, for instance, taking the court through, step by step, the relevance of each of the questions that we wanted the Electoral Commission, to answer. And then also, when Learned Counsel for the first respondent was on his feet, he himself pointed out quite clearly that the issues we raised were contained in their answer.
So hearing of the matter continues on Tuesday, and the main business of the day is first and foremost that the memorandum of issues are to be filed by the parties in the case. This is simply a detail of what the parties opt or hold the view to be critical to the determination of this particular dispute, and so they are going to propose the questions that they think the court should be asking them to provide evidence to support, and once the court adopts that, then the trial proceeds from there. Reporting for JoyNews from the Supreme Court, my name is Joseph Akable.
And this is still the AM show. I've been doing this with Enimado. We've talked to you through the things that have been happening so far. One of the key stories that have been reported upon, of course, if you take COVID-19 away, is what is happening in the Supreme Court. And as you've seen in the reports that Joseph Akable put together, the Supreme Court has dismissed the motion by the former President John Mahama that was seeking to permission to elicit answers to some of the to those 12 questions, or the 12 interrogatories, to put it legalese, more legalese, from the Electoral Commission. Now, among others, as you may know, the lawyers for the petitioner are asking the EC to answer questions about whether or not the National Communication Authority played any role or facilitated in any way the transmission of the election results to its headquarters. Now, why is that even relevant? Yesterday, Dr. Ayene, who is part of the legal team for Mr. Mahama, had a lengthy discussion with my colleague Evans Mensah and Okojo Ponkruma, who is the spokesperson for Mr. Nana Addo Dankwa Akufo-Addo, the president's legal team. This morning, we'll carry on that conversation a bit further. I have two people joining me on the line right now for that conversation. Dr. Opoku Edusei is a lawyer and also a part of the MPP's communication team. He's joining me via phone. Doc, thank you. Good morning.
Yes, good morning.
Also joining us in this conversation is Abraham Amaliba, who's also the lawyer or part of the legal team for the NDC's John Mahama, who's also spokesperson for the legal team. Ms. Amaliba, thank you. Good morning.
Good morning to you. Good morning.
Okay, so this morning you're expected, your teams were expected back in court at 9:30 a.m. We understand that you'll be filing your memorandum of issues?
That is so.
What are we to expect?
We've also filed to, as it were, inspect some documents. So
right.
That will also be put to the court. That will also will draw the court's attention to that. We want to inspect some original documents from the EC.
Right, and I will go into that. I actually have you have listed 6 of the documents that you want to inspect, that you request to inspect. We'll go a bit into that. But regarding the memorandum of issues, are there any highlights that we should know at this point?
No, whether or not our main issue is whether or not by the wrong declaration that was done on the 9th and gazetted, whether or not the Article 63(3) have been breached. Because 63(3) says that the person to be declared should garner or attain more than 50% of the vote. So that, for me, will be one of the main issues for the court to determine.
63 has been breached.
Yes, 63(3).
Dr. Edusei, on your side?
I didn't get a full import of his question, but
I was actually asking what we're to expect, knowing that today you're supposed to be filing a memorandum of issues.
Well, there's an agenda for today, and that was given in the order by the Supreme Court yesterday. So that's what we'll comply with and make sure that the issues are filed for us to make progress in the pre-trial process.
Do you want to help us with what's on this agenda, our viewers?
You mean the content of the issues?
Right.
That we will need to be able to file before it comes out. But
I mean, not necessarily everything. Not necessarily everything. Because if you listen to Mr. Maliba, for example, he's giving us the sort of, the import of what they seek to I mean, already you have what the reliefs that you're seeking, the reliefs that they are seeking, and your response has come. But I think he's saying that whether or not Article 63 was breached is one of the fundamental issues that will dictate the memorandum of issues. What can you say on your side?
You know, we will be interested in the substance of whatever happened on the December 7th.
I lost you briefly. Can you say that again, please?
I am saying that, can you hear me?
Yes, please.
Our focus will be on the substance of what transpired on December 7th, vis-a-vis the declaration on December 9th. Whether, if there's a slip, as they have stated, whether that goes to the substance of the validity of the election, because that's what the Constitution talks about. And that's what our focus will be on.
Okay. Ms. Amalva, let me engage you a little bit. Yesterday, we spoke to, the spokesperson for the Nana Dankwa Akufo-Addo's legal team, Kojo Ponkruma, who indicates that essentially everything that is happening is theatrics, as he describes it. It is something that the NDC is doing to necessarily delay the process because, as he puts it, he contends you cannot prove your initial the initial points that you made, the reliefs, that you cannot prove reasons why those reliefs should be given you.
That's a segment of his own imagination. You have a lead counsel like Chikata, and you question whether or not you can prove something. What played out yesterday during the application, the clear testimony of his ability to prove all those things. Yesterday, in moving his motion, you saw how he was being heckled and how he came up short. We will not ask for a relief that we are unable to prove. Even on his feet, when there were interjections that were meant to scrutinize him, you saw how he dealt with the questions and how the judges were all quiet and listening to him. So please, that is his case that we cannot prove. But he's not a court. In the court, we have two sides. And the third one is the judge. Your side, my side, and the judge's side. So you should leave that responsibility to the court, for the court to pronounce that we were not able to prove. But not for him. Does he know what the judge is going to say? Or he has conference with the Supreme Court and he already knows what they are going to say?
He bases his argument on a few things, and let me just go through a few of them for you. First of all, he says that Mr. Chachikata in court abandons your claim of winning the elections. He says over the time, the NDC has consistently told your supporters that the NDC, John Mahama, won the elections. But he says that in court, while Mr. Chikata was making his argument, he abandons that fundamental point and refers or focuses more on the errors that occurred in the announcement of the election results. That's one of the things. He also says you are raising matters that are not necessarily in question. There are issues that in the 12 questions that you listed that some of them are very obvious. The answers to some of them are very obvious. These are part of the reasons why he says the NDC essentially is on a fishing expedition, and you are doing so deliberately so you can get more time on camera and, with in public opinion, and to waste time.
But John Mahama should know that what clients see, and I'm probably because he's not practicing, that's why. What clients say is different when they come and meet their lawyer in conference. The lawyer will tell them that what you are saying now is true, but it's difficult to prove. So can we drop this one and then deal with this one? Mahama's belief that he has won the election is different from the legal belief that the issue was sent to court should not be that clear. Chikata was not the one who went out to say that the NDC has won. So why should Chikata be tied to that statement?
But he's your legal counsel. Isn't that part of the fundamental argument you are making?
You don't understand. I'm saying that...
Help me.
When a client is at his office and claiming victory or in his house and claiming victory. That is different from when he meets his lawyers. Let me give an example. Growing up, you could follow your child, your friend to the mother's kitchen. You remove the meat in the mother's kitchen and eat. You go and tell the mother, "Oh, my friend, move your meat from your pot." Then your mother says, the mother says, "Provide me proof." Are you going to open the belly of your friend to show the meat in there? So it's not everything which is true, which can be proven in court. So you cannot attribute what the NDC said before going to meet their lawyers to, as it were, say that then Tachikata was not candid. The issues that are in court.
Mr. Maliba, I'm losing you.
Can you hear me?
Yes, I hear you. Please go ahead.
So we are now in court. We've put before the court some issues. Those are the issues you should focus on, and not what the parties said or did not say before meeting their lawyers. That's not what is important. You have a matter before you. We are saying that if you did the mathematics well, the arithmetic well, none of the two parties would cross the 50 plus mark.
Okay.
That's what is important. That's what is before the court.
Okay, very well. Dr. Duse, I just want to bring you in on this part, and we'll be moving on to first of all, the NDC has said that they seek to review. They seek to apply for a review of the ruling. That's number one. And today, they also issued a request to examine some documents. We'll go through that next. But Doc, I want you to just comment finally on Mr. Maliba's position that there are two different things, and also the issues that are running so far. The point is, why? Well, you seem excited, or your side seem excited that finally the case can move on, because that's what you said you were ready for yesterday. But what is the big deal in getting answers to some of these questions?
Well, thank you. I believe that it's not just an excitement, but it's the intentment of all Ghanaians that election petitions do not become drawn-out battles for months and for a long time in our court system, because they do not serve the ends of our development. It's for that reason that after 2013, we decided to change the rules so that we'll be able to have an expedited hearing of election petitions. So that it's not 8 months, and then Ghanaians will go to their TV sets listening to whatever is going on. It's also even in the interest of the NDC that if they believe the president wasn't duly elected, that the outcome is known in time, so that if they are victorious, then they could be given the mantle of leadership to govern this country. So in all situations, when things are done in a very fast way, of course, following all due processes, the end of it is that it's supposed to serve the Ghanaian interest. So let's have that in mind.
Okay.
The second point is that I believe it's quite preposterous for my colleague to claim that what the Honorable Minister and spokesperson said, that NDC hasn't gotten the case. That's why they've changed their story, meant that they is in league with the judges and having conferences with them. I mean, that should never even be said, because no one will even dare do that. Supreme Court is an honorable institution, and we know that it's that body that has the final say in our adjudicatory processes. So let's respect them as such. The third point that I want to make is that looking at what my colleague had just said, it means that they had a story outside before coming to court, and that story is now different from what they are in court. And he's saying that that doesn't matter. But what matters is that the petitioner who claimed that he had won the elections and therefore should be declared, and his party that claimed that they had won the elections and should be declared, they are the ones in court trying to assail the declaration. So when you come and mount the witness box and you are confronted,
Mr. Maliba makes the issue. Doc, Mr. Maliba makes the point that what is different? What they have said, perhaps the flag bearer has said in public to their supporters is different from what is in court. What is in court is a substantive matter that we're discussing here.
You see, they think that whatever is said outside the court can never come into the court. It can be played out to you on the witness stand, and then you'll be confronted to explain why, at the point of making those pronouncements, you knew that you had not won, but you decided to lie to Ghanaians. They should not think that it was just politics as usual. It was a very serious business we were engaged in to get the leader of this country. So if you knew that you had not won, and then you presented a story that you had won, whereas you knew that you had not won, that can be made to be confronted. You can be confronted with it. And at the end of the day, if you are not able to offer very plausible explanations, it will go to your credibility as a witness. Okay.
Mr. Maliba, let's move on to what is supposed to happen today as we move on with this discussion. You have filed to, you are requesting actually to study some document, to inspect some documents, and I'll just list those here. One, you want to inspect the originals of the constituency presidential election results collation forms for all constituencies, the originals of the constituency presidential election results, the summary sheets, the originals of the regional presidential election results, the originals of regional presidential election results summary sheets, the originals of the declaration of the presidential results form, and then the records of the alleged update to the purported declaration of the presidential election results on December 2020 of the 4 constituencies in the Greater Accra region. Exactly what are you after here?
You know that Jane Mensa, in declaring the results, would have to cite all these documents.
Okay.
We know that she will not declare results in a vacuum, except that maybe that's what she did. So we believe that these are documents that aided her to come to that conclusion that she came to on the 9th of December, and the subsequent amendments and changes that she did at the time. And so we are requested to inspect these documents because, don't forget, our case in court is that nobody attained the more than 50% mark as required by Article 3. Now, in inspecting these documents, we would come to a firm conclusion.
Hello, Mr. Maliba. I'm getting some feedback from your end. I'm not quite sure what that is. Can you hear me, sir? I'm still having a lot of issues, but you were making a very strong point there.
Is it okay now?
Yes, perfect. Please go ahead.
Okay, so the inspection of these documents would bring to our attention, the court's attention, whether or not the declaration was done without any influence somewhere, 1. 2, whether the declaration was done having in mind or taking into consideration all these documents, which are the primary documents for the declaration. And so it is important that the people of this country know what was contained in those documents, so as to understand how those conclusions were reached in the declaration.
I see. Couldn't you have done this a bit earlier?
From where? You remember religious leaders, well-meaning Ghanaians, called the EC to invite the NDC and then the MPP and do this exercise. I remember the chief imam said so. They were adamant. So the only place, the only forum that can compel the EC to do what we are requesting is the court.
And can't these facts come up during the case itself, especially since today you're supposed to have, continue with the case management?
No, this is not going to impede what is happening today. We are just asking, we're not going to inspect them right here, there, and then when we are in court. No. She may not assume have brought them to the court. So we are asking that she be aware, if the court agrees, that we'll be inspecting these things. That's all we are saying.
Okay, and so essentially it's not an application, as Dr. Yene puts it yesterday. He says that it is a request, which means it can't be
it's a request.
easily rejected.
It's a request that we are making, that we want. But see, anybody who is disagreeing with this one too must be somebody who is not interested in getting to the bottom of this matter. Anybody who is trying to protect the EC from providing these documents, which are public documents, which are state institution documents, must be hiding something.
You're under the suspicion that someone is seeking to stop the EC from providing all these documents?
No, I just heard you say that it can be granted, it will not be granted. This is a harmless request. Show me the originals of what you used to declare. How is this going to be injurious to anybody, any institution? How is this going to be a negative? How is it going to even affect anybody? Except there's something to hide.
And if there's something to hide, what can you do about it? You're in court. You just have to go through the process.
I have told you that this exercise is both for the court and for the public. The Ghanaian population were the ones who killed and voted on the 7th December. They are watching. They also make their views known.
Okay. Let me take Dr. Duse's thoughts on all that you have said. Doc, so this essentially, as Mr. Maliba tells us, will not impede what is going to happen in court today. So essentially the process will go on, which goes to the point that your side has made consistently that the NDC is seeking to slow the process. So that tackles it. But he's talking about the things that they are seeking to achieve with the examination of these documents. How does that sit with you and your team?
Well, you know, he made, when he was ending, quite a sweeping statement that anyone who would disagree with this has something to hide. It's like
no, the point he makes, sorry, let me just correct that. He said the point he makes is that anybody who tries to stop the EC from providing these documents obviously has something to hide.
Yeah, that's a disagreement I'm talking about. So they have put out their position. That they should be made to view the original copies and possibly make photocopies of documents in the custody of the Electoral Commission. Fair enough. Discoveries are part of legal processes. But if you end with a sweeping statement that anyone who will think otherwise, and I think the Electoral Commission could think otherwise, I think NPP will think otherwise, it means that that person has something to hide. No, that means that's quite too sweeping a statement to be made by a lawyer.
So why would you disagree with a harmless request in the words of Mr. Maliba?
You are making requests for discoveries. You are supposed to be guided by law and the rules of the procedure.
Okay.
Though yesterday the Supreme Court ruled on their application and said that they will not allow sweeping application of CI 47 in this election petition processes. That's part of the ruling they gave yesterday. Other than that, CI 47 is the High Court rules, which at times in the past is used by the Supreme Court for its practice when they realize that there is inadequacies in CI 16, which is the main Supreme Court rules. But Supreme Court says that for election petitions, there have been amendments based on our experiences for there to be expedited processes. For that reason, we should be careful when we are importing from other rules for its operation in the Supreme Court. So you can make requests for discoveries. And it did happen in 2013 when the NPP requested that Electoral Commission should share the pink sheet. You know the ruling that came out? The ruling was that since the electoral got the declaration forms, there were counterfeit copies that were given to NPP and all the political parties and their agents. That counterfeit copy is as good as the original copy. So if the Supreme Court rules against you because of this precedent,
it doesn't make it such a big deal, even if they have the carbon copy to show the original. That's it.
You know, sometimes if they realize that you having a carbon copy and requesting for the original will not make any difference because you have one already. Your agents were in the 38,622 polling stations, the 275 collation centers, and you had your copies. So wherein lies the relevance of the court saying that go to EC and get all the copies given to you? In any way, the Electoral Commission has already published these forms and declaration documents on its website.
Okay.
So you are now saying that you want the original, but if you realize that having the copies is the same as having the original, and the Supreme Court has already pronounced on that, and you don't take a cue, and then you lose on it, and you say that it means that someone has something to hide. That is very unfair to all the parties involved. It's actually unfair to the bench, and we should not actually put out such kind of statement because we want to our support base to feel good about it. You can win, you can lose on it. When your argument is not solid and then you lose, you just take it in good faith and proceed on with the case. He also said that he thinks that should not affect the other Supreme Court made, that they should all file their issues. I think so. I think that when the court rules on this, the business for the day is for us to have the issues set down. There will be similarities in some of the issues, sometimes the wording issues. The court is then given the power to see which ones to tinker with so that there is coherent issues set down for this trial to start. It is the interest of the Republic and that of all Ghanaians that we know the end of this process so that governance and development of this country can proceed.
Mr. Maliba, you do have, and NDC has insisted that you have your document. You said you have all your pink sheet. If they are the documents that you listed in your request to examine, you should have copies that are equally as good as the original.
That does not preclude us from seeing the original. He's made a point, and in his submission, he indicated that we should be guided by an earlier ruling. We were guided by an earlier ruling which allows for interrogatories. What happened yesterday? So that
it's at the court's discretion to grant that or reject that, isn't it?
So he shouldn't say that in the past there was a ruling, and for that matter we should be guided by that ruling before making those requests. Just as it happened yesterday, that the same court granted the MPP the opportunity to ask questions of Farijan, but this time said no. That ruling that was also given by the Supreme Court in the earlier case in 2012-2013 may not necessarily hold. So we have every right to request for it. Nobody is saying that the court would not accept our application or deny it. We know that when you go to court, you either have your application granted or denied. But we are also saying that in instances such as this, where the document, which is a source document, a certain individual.
Mr. Maliba, I lost you briefly. Can you say that again?
In instances such as this, where the custodian of the document is the one whose document can either or not approve of what document we have or disapprove of it, you can ask for the original. And that's what we are doing, because the proper source, the custodian of that document is the EC. Now, if you say that we have copies, what if our copy has been tampered with? So you go to the original source and hoping that the original source, being the custodian of that source, will provide you with the accurate figures. And so this, like I indicated, is a harmless request.
Okay.
And I don't see how this can be injurious to the EC if they provide us with those information.
And like you said, this will not affect the movement.
Not at all. It is not going to delay any process, because this is a request we are making. Okay. They can go back and bring it in 3 days' time or in 4 days' time.
Okay, Dr. Adusa, you wanted to make a point.
Yes, I wanted to make a point that we should not put a spin on what I said by misleading the public. That I said that there is an earlier ruling, and they also had an earlier ruling, and for that reason they still lost and that kind of thing. All that I was saying was that they should be guided by precedent. Of course, we all know as lawyers that the Supreme Court is not even bound by its decisions, and they can vary it as and when they need to vary it. In the particular case of yesterday, the Supreme Court decided to vary its decision of not allowing for those interrogatories because the rules have changed. You know, we spent 8 months in the Supreme Court in 2013, and the legislators, including NPP and NDC members, realized that that was not in the ideal interest of Ghana. So they decided to change the rules that for election petitions, we want everything disposed of within 42 days, right? Of course, the days can be tinkered with, but it doesn't mean that you can double 42 days into 84 days. So the court decided to be guided by the rules as have been set by Parliament, because CIs go through Parliament and before they come out after 3 weeks as law. And therefore, it's binding on the court for them to apply. So that's the difference they have. And in the case of the discovery, I'm saying that they should be guided by what has already happened. He mentioned that their copies might have been tampered with. By who?
No, he's talking about the original copies. He said you can have a carbon copy, but the original copy could be tampered. He's saying, what if it is tampered with? Well,
Doreen, is tampered by who? When it was in the custody of your agent, you don't even trust your agents to keep the sanctity of your pink sheet, and you relied on it and made declarations that you had won. Let's take these things very seriously. But in any case, I wish them well, but when they don't get what they pray for, they should not go out and bastardize the judiciary as if they don't know what they're about. These are people who taught us and are more experienced than us on the bench. And we should give them that benefit of the doubt. That is the highest court of the land. So any pronouncements we make will go one way or the other to affect us in the future.
Mr. Waliba, I just want to point at something that Mr. Opon-Kuma said yesterday. You want to respond to what he said? Yeah.
This whole civilization that the judge's ruling cannot be criticized, and that when you did that, it amounted to bastardizing the court, must be taken out from a democratic as ours.
Well, Mr. Malava, I guess there's a difference between. I guess there's a difference between disagreeing with the ruling of a court and bastardizing.
If you describe disagreeing as bastardization, I'll take you on. In any case, he is talking about CI 99 that have changed the rules. He should point to me in CI 99 where it is said that applications such as what we did yesterday is not allowed. Where is CI 99? That.
But it still comes back to the discretion of the judges.
We are reversing it. He should rather tell us where it is in the CI.
Okay.
Which
application.
Okay, gentlemen, when you talk over each other, our viewers can't hear you.
Yes, so which rules? I have the CI 99 right in front of me. They should show me the section that says that such applications are not allowed. The fact that the CI talks about expeditious trial does not mean that must take precedence over providing justice.
But you agree that in this process, the discretion of the judges is
no, it's a discretionary power they have.
Exactly.
So you can make all the arguments, you can cite all the laws like Chachi did yesterday. He, among all the three lawyers, was at his best. Everybody saw that he made relevant points, but it's a discretionary power they have, so they exercise it in,
okay, I like the point you made because it allows me to bring in the point that a spokesperson for the President's team made yesterday on PM Express. Let me just go through that a bit with you. So, Mr. Opon-Kuma indicates that Dr. Ayene's explanation of the questions you sought answers to yesterday, for him, was easier to understand, or that Dr. Ayene made the point clearer than Mr. Chachishikata did in court.
I didn't hear Dr. Ayene.
Okay, yes. Mr. Ayene was explaining that, for example, the question about the NCA's role in the transmission of election results, that they wanted to understand, or you wanted to understand, whether or not in the chain of the process there had been a breach. And answering those questions could help, because Kojo's contention was that some of the questions, I mean, they weren't questions at all, because the answers were pretty obvious. And Dr. Ayene's position was that for the NCA, for example, they wanted to understand if there were any possible breaches in the chain. in the chain of, the process. Kojo's point, let me just refer to this quickly. Kojo's point was that well, let me try and rephrase this. He said that you did not list in the questions that you sent, that for which you sought answers, you did not list, for example, the explanation on why you needed answers on the NCA's role in the transmission of election. And that perhaps if that had been done, the judges would have ruled differently.
That is wrong. The rationale for a question is not a question. What Kojo and Paul Nkrumah got excited about was because Dr. Ayine is privy to what the question means, and Dr. Ayine was providing the rationale. That doesn't mean that is the question. The rationale is not the question. So the judges, like you would normally interject, would ask, what is this question supposed to achieve? Then you can now bring the rationale. You don't ask rationale as a question. That's a rationale. What's the reason behind the question? That's what was explained on your program. That's different from the question. So those were the questions. And now, the rationale or the reason behind those questions is what was explained maybe in the evening of the
So for example, whether or not the role of the region coalition centers, the question about the regional coalition centers.
Hello.
Hello, Ms. Almalva, can you hear me?
Hello.
Ms. Almalva, can you hear me? I do hear you.
Hello.
Okay. Ms. Almalva, I can hear you, but it looks as if you can't hear me.
No, I can hear you now.
Okay. So
did you get my submission about the rationale?
Yes, you said that the rationale cannot be mistaken to be the question, but is it possible?
So the questions are the right questions.
Is it possible that the question could have been broken down?
Are now what was being explained.
Yes, but is it possible that the explanation given as what you say is the reason for the question could have been indicated in the question to make it a bit clearer and easier to understand?
No. Interrogatories are direct, straightforward questions. And you realize that on his feet, Chachu was making the point that some of the questions just need yes and no. So the questions must be specific, direct, pinpoint. You may want to find out why, and that is for the court. The court. And that's why the judges sometimes will interject. You remember one of the judges asked where can he point at where in the pleadings or the petition does this question arise from? And he did that. But he wouldn't say that I am asking this question because paragraph this and this says this. No, those are rational, and it doesn't come in the interrogatories.
I see. But also the point that is made is that these questions can easily be asked during cross-examination. Yes,
nothing has been lost anyway. The only thing is that we were trying to achieve the same purpose for which the court says that the CI 99 was trying to achieve, that is expeditious trial. Because these 12 questions wouldn't have been asked again in cross-examination. Now you cannot falter Chachu Chikata if his cross-examination is keeping long because you denied him this opportunity, which would have shortened the length of questioning. So yes, for those who thought that this is a loss of no, it's not lost. These same questions can still be asked during cross-examination.
If nothing is lost yesterday, why is it that one of your legal team members described the ruling as legally untenable?
Legally untenable because the rules allow for this. And then also legally untenable because when you look at the ruling, talking about CI 99 having amended or having precedence over CI 47, where to engage in application for interrogatories was untenable because that's what I'm asking my colleague on the other side. There's nowhere in CI 99 which says that you can no longer, because of expeditious trial, you can no longer request for interrogatories. Okay. So that's where he said it was untenable. It was not based on any law.
Okay. Dr. Duse, I need to wrap up, but I'll take your thoughts on what Mr. Maliba has said so far. But then the final thing that I want us to, wrap up with is that according to Martin Pebu's calculation yesterday, we have barely 22 more days if we are going by the 42 days set aside by the Supreme Court.
Well, that can always be modified when the court realizes that they will not be able to work within that framework. So in the CI 47, he mentioned there's timeline within which judgment can be given, but we know that judgments are given outside those periods. But when the delay is inordinate, that's when it becomes improper. And when he was ending, he said that he disagreed with the court's ruling that CI 99 supersedes that of CI 47. Doreen, as I said, CI 99 is specifically for elections, election challenge, presidential election petitions. And CI 47 is a high court civil procedure rules, right? So when there is a specific rule in law to guide the Supreme Court, you realize that the general rules of a high court, which the Supreme Court and sometimes adopt practices from, will not have that precedent. And it's well captured in several rules of interpretation that when there is a specific statute governing an aspect of the law, you can't rely on general one as superseding that of the specific one. It's well-established rule of interpretation that we have.
Okay.
Secondly, he said that they can raise their issues again in cross-examination. Yeah. And that one, no one begrudges them.
His issue is that might even prolong the process, and that is what they were seeking to stop.
The time for trial itself is also governed by the CI. There are timelines within which you can continue. So we'll not be having pink sheets in our hands like how in the previous years we had, and a single pink sheet being held like a confirm, and then all the time several questions on it. If you become pedantic, the court will give you timeline that you are given 3 days to do this kind of cross-examination.
Make that your final words for me, Doc. Make that your final words for me.
All right. So, and then, yesterday, an aspect happened concerning the role of NCA in the transmission of the elections. Right. I had seen documents on social media in which a purpose or supposed letter had been written by NCA to the office of the chief of staff to get access to some data, right? From what I know, that document which was being shared on social media, and I believe that precipitated that question whether NCA had any role in EC's transmission. It's fake.
The letter is fake.
When they were faking it, they were not even too smart. The name of NCA, right, and what is on their letterhead is National Communications Authority. In this case, if you look at the letter, that letter which is in the social media, the name is National Communication Authority, to bracket NCA Ghana.
But did you say it is fake? If it's fake, then that's different. It doesn't matter the name. Is it fake?
What I'm saying is that when they were faking the document, they omitted even to get the name of NCA right.
Okay.
And on the face of it, once you see it, you see that it's fake.
Okay, no.
Like it was being shared on social media, and I'll be surprised that is the document which actually influenced them to make that request, whether NCA had any role in transmission of election results.
Okay, I ran out of time, but I'd like to say a big thanks to you. Mr. Maliba, it's only fair that I give you the final word as well. Yesterday, Kojo Ponkum also indicated that they suspect you might want to even file to stay proceedings as part of what he says is your plan to slow the process.
Are you talking about their legal objections, their preliminary legal objections?
No, yesterday he said on the show that they suspect that, or they expect you to file for stay of proceedings.
Oh yes, it is not within, it is not out of our power. We indicated that we wanted to study the ruling. This can go for a review, and so I'm here to meet the lead counsel and to understand what next to do on that ruling. So it's within our rights to do that. So that is not far from being done.
Dr. Edusei has made quite a number of observations. You can wrap up with your thoughts on that as well.
No, you see, the CI 99 has not come to stop the proceedings that are allowed in court. For instance, CI 99 does not say that you can't bring in an application. CI 99 should not be seen as truncating all other processes which normally a litigant or a party in a suit would have. And so when they talk about CI 99, I always want them to point at which sections that says that, for instance, interrogatories are not allowed. Let me see that clearly. CI 99 has not prescribed those processes that are allowed in our court processes. And so I find it difficult to understand why every little thing they say CI 99 has come to amend it. And yet, there's no such amendment, there's no such provision which says that because of expedition, you cannot bring this application or you cannot bring that application. I think we need to understand that the party in court has every right to avail to himself all these processes that are allowed in a normal trial.
Mr. Maliba, I'll say a very big thanks to you. Dr. Edusei, I realized that you kept referring to me as Doreen. It's Gifty, by the way. I just thought that that's okay. I know there's an under somewhere, so sometimes it gets people a bit confused. Dr. Edusei there, Dr. Foko Edusei there, who joined us in this discussion, is a lawyer, also a member of the NPP's communication team. Also joining us was Abraham Maliba, who is a member of the NDC's legal team, talking about what to expect later today, even as the NDC, files a request to examine some more documents. Thank you, gentlemen, once again. At 9:30, we'll definitely be back in court.